Thank you and good morning and welcome to what promises to be an insightful and thought-provoking discussion on AI and justice, sprinting towards a vanishing finishing line. As we convene at this distinguished conference, we find ourselves at the intersection of technological innovation and legal evolution. Artificial intelligence is not a distant prospect. It is already shaping our legal landscape, transforming how we practice law, administer justice, and ensure access to legal services. However, with these advancements come significant ethical and practical challenges. As AI continues to develop at an unprecedented pace, we must ask, how can we harness these innovations without compromising the foundational principles of fairness, accountability, and justice? How can we ensure that AI serves the common good rather than reinforcing systemic biases or eroding public trust in our institutions? Yesterday, we saw the adoption by the Commonwealth Lawyers Association of the Malta AI Declaration 2025, which establishes 7 principles directed to the powers charged with legal services to ensure that deployed AI-enabled systems and services are used to uphold, ensure, and promote these principles. Today, our esteemed panel will guide us through these critical issues. We will explore AI's role in legal practice, particularly in areas such as contract automation, dispute resolution, and legal research. We will examine its influence on the judiciary, from predictive tools in sentencing to AI-assisted decision-making, and consider what safeguards must be implemented to preserve fairness. Furthermore, we will assess AI's potential to enhance access to justice, particularly for marginalized communities. Most importantly, we will address the ethical dilemmas AI presents for legal professionals, issues of bias, transparency, accountability, and governance. How should AI be regulated to align with the core values of our legal systems? How can we ensure that AI remains a tool that strengthens justice rather than diminishing it? We are privileged to have with us leading experts in this field. Professor Richard Susskind, a pioneer in the intersection of AI and law, will commence our discussion with his keynote speech. Following that, Mr. Ian McDougall, a renowned authority in law and technology, will further enrich our discussion with his insights. I encourage each of you to engage actively in today's session. Our discussion is not merely theoretical. It will shape the future trajectory of AI within the legal profession. Before passing the floor to our distinguished panelists, we have a short video with the avatar of Professor Louis Franceschi, Assistant General Secretary to the Commonwealth, that will help us to set the scene for this plenary.
Ladies and gentlemen, it's a great pleasure to welcome you all to this Commonwealth Law Conference. Although I may look and sound real, I'm an AI-generated avatar. I was created when Louis Franceschi, who is currently sitting here with you, asked me, AI, to generate a greeting to all delegates and explain how the future is already here. Avatars like me will be made available on the internet. We will have in-depth knowledge to advise anyone from any country in any language on legal matters for just a few pounds. At the Commonwealth Secretariat in London, we are combining AI, innovation, governance, and justice in ways never explored before. For example, we have generated a dialogue between avatar ministers of health, law, and finance who discuss how to eradicate tuberculosis in Kenya. Artificial intelligence formulated the right questions and answers based on existing data, At this cabinet meeting, Avatar ministers give the president accurate data-driven solutions to ongoing challenges. While this is an experimental pilot, the rapid evolution of generative AI will make such AI governance models more useful and precise. I know you still do not believe me when I say I'm an AI-generated avatar. If I explain this in Hindi, will you believe me? Lekin vasmen, main ek cybernetic rukna hun, and Arabic, ilken filoqueka and mukruk cyberni. And of course in French, mais en réalité, je suis une création cybernétique. And in German, ich bin nicht real. Ich bin nicht Louis. Ich bin ein Avatar, der erschaffen wurde, damit du mir glaubst. Now, hold on to your seats and get ready to attend one of the most exciting law conferences ever and explore the future. Thank you very much. Grazie hafna u merba Malta.
Now I invite Professor Susskind to share his insights. The floor is yours.
Attorney General, honourable ladies and gentlemen, a great pleasure to be here. In 1990, I spoke at the Commonwealth Law Conference in Auckland in New Zealand, and my subject was artificial intelligence. I'd written my PhD in Oxford from 83 to 86 on AI and law, and I'd then gone on to develop the world's first commercial AI system for lawyers. So I devoted my 1980s to AI, and at the 1990 conference presented some of my findings. And my message that day was that one day artificial intelligence would have profound impact on the practice of law, on access to justice, and in the administration of our courts. I stand here 35 years later, and again my subject is AI. And my message today is rather different. My message today is we are entirely unprepared for this technology that is advancing at a remarkable rate. And I want over the next 15 or 20 minutes or so to give you a flavor of how this technology is advancing. Can I ask, first of all, was anyone present at that 1990 presentation? A few people. That means I can't romanticize or fictionalize what I said at that time. I'd love to talk to you after the conversation here. Let me start with two stories. The first is about the London Times. I periodically write for the Times, and in early 2023, I was asked to write an article on the impact of artificial intelligence on lawyers. 800 words I was asked for. So I tried an experiment. I went to ChatGPT, which is the most common of the current AI systems, and I said, can you please write 800 words for me on the impact of AI in the law, in the style of and based on the works of the author Richard Susskind. And out came this draft. And I looked at it, and in the way we all do, I thought, well, it's okay, but it's not really as good as the real thing. 6 months later, half a version later, so I'm moving from version 3.5 of GPT to version 4, I made the same request. I printed out the produce. And that was when a shiver went up my spine. Because that day I could see before me something that resembled the kind of draft I would produce. And I thought that day, imagine when we have GPT version 6. There will be no need for me as a journalist, as a writer, wearing that particular hat. That's the first thought I had. And I went on to think the market will have no loyalty to my way of working. If we can, for example, in the future, generate columns not based on one expert, by, say, the leading 25 experts, and ask it to write in the style of, say, Ernest Hemingway rather than mine, you begin to see we'll be able to produce far better material than we do today. Indeed, we may look back and think it's bizarre we used to ask individuals to write columns. The second thought, or the second case study, is more advanced. It belongs to the field of brain-computer interface. There's work going on around the world about how we can communicate directly with machines. 29 patients were suffering from epilepsy, and they tried an experiment. Attached to each of the surfaces of their brains were electrodes, thousands of electrodes in all. They were attached for the purposes of monitoring their difficulties. But the experiment they tried was to play the same piece of music to each of them. So they played this piece of music, and they captured the data, the brain activity, while they were listening to that music, 29 patients. And then using a form of predictive AI and a form of generative AI, the system reproduced the music that was consistent with the data it had captured. And you can listen to it online. It's recognizably, but spookily so, Another Brick in the Wall by Pink Floyd. Pause to think about this for a second. We now today have the technology that allows us to attach electrodes to the surfaces of human brains and essentially peer into their minds to know what it is they're experiencing. If we think we've got privacy problems with conventional technology, we've got far graver problems coming down the road. And remember, too, of this system, that's the worst it will ever be from now on. These systems are getting more and more capable. So I think, on the one hand, of my job as a writer, and I think, on the other hand, of the remarkable advances in brain-computer interface, and I ask the question, where is all this leading? Because what we're also seeing is an explosive growth in underpinning technologies. I don't want you to bother about the technical details, but please note that the main underpinning technology of AI today is known as neural networks. The power of neural networks is doubling every 6 months. Those of you who remember your maths will therefore calculate that over a 10-year period we'll have 20 doublings, 2 to the power 20. That will be a 1 million-fold increase in the power underpinning our AI systems. So we can, and in my view, should be amazed at the power of these technologies today. But the idea by 2035, the underpinning technologies, and this is conservative, will have improved 1 million-fold should give us pause for thought. It leads to another point, which I find both exhilarating and disconcerting. If you look back at the origins of AI, maybe 1950 or so, you'll see that breakthroughs came about every 5 to 10 years in the early decades. Today, breakthroughs in AI are coming every 6 to 12 months. This means by, say, 2030, I can't prove this, but if you follow the trajectory, it's likely our lives will have been transformed by technologies that have not yet been invented. Now, you may say that's science fictional, but I can take you through technological advances over the last 30 years, which show that we simply do not anticipate the next generation of systems. And so in our policymaking and in our strategic thinking, we have to look beyond the technologies we have today. We have to speculate as well as extrapolate. But I ask again, where is all this leading? And I've recently, and I'm going to only mention it once, I've recently published a book called How to Think About AI, A Guide for the Perplexed. And I can't recommend it highly enough. And in that book, I identify 6 hypotheses about where AI is heading. And note, these are 6 hypotheses taken from the AI community. I should say I'm half an AI person and half a lawyer, half a law professor, half an AI expert. But I looked right across the literature. I speak endlessly to people working in the field, and there's 6 hypotheses, and I want to share them with you. The first is the hype hypothesis, and that says something like this. What we have today is remarkable, but it's only superficially remarkable. These systems still make mistakes and make serious mistakes. The data upon which they rely is irredeemably flawed and often biased, misogynist, racist, and so forth. And although, therefore, we're having some excitement with these current systems, we can't fully integrate them in our lives because they're simply not reliable. And the bubble is going to burst, and in a few years, we'll look back and think, what was all the fuss about? That's the hype hypothesis. Many academics think this, many social scientists think this. Then you have, secondly, what I call the Gen AI Plus hypothesis. You've heard a lot about generative AI. These are these systems that generate text or music or video or, crucially, can themselves write computer code. And the best example is ChatGPT. Now, those who hold the hypothesis of Gen AI Plus say that these systems will actually become reliable. We'll find ways of auditing and removing the unsavory data, and we'll find ways of removing the errors that they generate. So much effort by the industry is going into that, that at some stage, that's the level generative AI will come to. The systems we have today, we'll have them entirely reliable, and they'll be fully integrated into our lives and our labor. However, those who hold this thesis say the AI is not going to go any further than that. What we're seeing today is really the limits of these machines. The third hypothesis disagrees, and it's the AGI hypothesis, artificial general intelligence. And this is where it gets interesting. The thesis of AGI is that these machines at some stage will be able to match human performance at all cognitive tasks. They'll basically be able to do everything we can do. And already they can do some of what we can do. But the idea is right across the spectrum of tasks that require humans with brains, machines will be able to match our performance. That's called artificial general intelligence. And many of you will think this is science fiction. If you'd ask most AI, people working in AI companies, say 3 years ago, when will AGI come about? Most of them would have said 20 to 40 years, if ever. If you ask people in AI companies today when they think AGI will come, they'll say 5 to 10 years. If AGI comes, it will be the single most significant event, in my view, in the history of humanity and civilization. And remember, I'm only at the third hypothesis. The fourth hypothesis is the superintelligence hypothesis, first formulated by a man called Nick Bostrom in his book called Superintelligence. And in this, we all rely on a man called Irvin Good, who in the mid-1960s said this, that if we can invent computer systems that can match human performance, that's the last invention humanity will need to make, because these systems themselves will be used in self-improving, in developing new versions of systems, and we're already seeing that with the AI systems we have today that can write code. And so what you will have is this vortex of what they call recursive self-improvement, and these systems will very rapidly develop to be unfathomably more capable than humans. That's the superintelligence hypothesis. The fifth hypothesis is the singularity hypothesis, and that's been best promoted by a man called Ray Kurzweil in his book, The Singularity is Near, and his book, The Singularity is Nearer. And he has been so remarkably prescient over the last 40 years, it's folly simply to ignore him. He predicted 20 years ago that we would have AGI by 2029. That's mainstream thinking in AI companies today. He predicts we'll have the singularity by 2045. That's when humans and machines will begin to merge. A new generation of entity called the transhuman, where we as humans will be digitally enhanced. In one sense, we already are today. What you have on your mobile, and therefore access to the internet, is a form of remarkable external storage. In the future, we will have bots roaming around us, the thesis goes, enhancing our intellect, our knowledge, and also expanding our consciousness. I'm not defending these theses just now, I'm simply laying them out for you. For when people say it's very straightforward, it's going to happen in AI, the AI community differ. The final thesis is the AI evolution hypothesis, and that's held by many physicists. Take Lord Martin Rees in the United Kingdom. He's the astronomer royal, he was the president of the Law Society, one of the great scientists of our generation. He puts it something like this. The universe is about 13.8 billion years old. Humanity's been around for a couple of 100,000 years. In cosmic terms, humans are simply a blink in the eye. And it may well be, he says, that the only lasting contribution that humanity will make to the cosmos is to develop these massively more capable systems that will in due course replace us. I know it's quite early in the day to be talking about replaced by AI systems, but I just want to lay it out for you. They're the sixth hypothesis. And these are all held by respectable, serious individuals. So what do we think about this? What should we do with this in law? The first thing to say is there's a distinction between the advance of technology and the adoption of technology. So even if technologies do advance to a certain stage, there are all sorts of obstacles that might stand in the way. Regulation, conservatism. There are moral issues. We may not want to use systems even if we can use these systems. But let's put the advance adoption distinction to one side and think about the drivers of change. Because what I try to do in my life when I'm predicting the future is think, what are the factors that might accelerate or decelerate any given technology? And when I'm looking at AI, I look at the trajectory. This idea that breakthroughs used to happen every 5 to 10 years, they're happening now every 3 to 6 months. I look at the exponential, explosive increase in the underpinning technologies. I talked about the power of neural networks. I look at what is known as the law of accelerating returns, this idea that the technology that is developed is used in the development of the next generation of technology. I think about the not yet invented systems. I think about the global scale of investment, trillions of dollars over the next few years. I think of the market, the evident market demand in governments, for example, to reduce cost and to increase productivity, and similarly in industry. I look at the hugely active and successful and vibrant startup communities around the world who are investing in developing in AI. And I look at the way in which AI, the field of AI, is attracting some of the most able humans on our planet. And I put all of this together and I say to you from the heart that the hype hypothesis is entirely implausible. We can discard that. I'm going to make two predictions now. I think we will have Gen AI Plus by 2030. That's to say the AIs we have today will be entirely reliable. We won't be talking about having humans in loops. There are many technologies we use today where we don't pause and think. When you use a calculator, you don't think, I'll do that longhand just to check. And we will have a similar level of confidence in our AI systems, I believe, by 2030, the early 2030s. The bigger prediction I'm going to make is fundamental to all our lives. It's fundamental to the legal system. It's fundamental to your children and your children's children. I say, and I use my words very carefully here, we should plan for AGI between 2030, coming along between 2030 and 2035. I'm emphatically not saying that it will, but I think there is such a significant chance of it for us not to have serious contingency plans in place, both to make the most of it in law and also to manage the risks. Later generations of humans would look back aghast that we hadn't taken this more seriously. Just before I say what the implications of that are in conclusion, let me just give you a couple of more concrete predictions. I believe over the next 3 or 4 years, for the remainder of much of this decade, the impact of AI will be in improving the productivity and efficiency of lawyers. It'll make us more productive, it'll make our courts more efficient. It'll essentially be what I call automation, which is grafting technology onto our existing ways of working. And this you'll find reassuringly familiar. You'll say, well, this is fantastic. What's the problem? AI will help us solve many of our classical problems. The difficulty is that as we go further forward, AI will no longer be sustaining and supportive of our current ways of working. AI actually will begin to displace the way we work. And in many ways, this will be advantageous for the community and society. We'll move into an era of AI-empowered individuals and organizations. Individuals, organizations who in healthcare, in education, in law and elsewhere will be empowered to do much for themselves as these systems become more and more advanced. But the path there's not a straight path from efficiency and productivity improvements to fundamental transformation. We're going to have to plan both in parallel. But the question I ask in my book, and I say the question of our time, is this: what if AGI? What if AGI? What does it mean for lawyers? What does it mean for those we help? What does it mean for our court system? What does it mean for humanity more generally? I'm entirely convinced that in the early 30s, both generative AI and near AGI will enable us largely to crack the access to justice problem. I have seen enough already, and I'm confident enough in the trajectories that we will have reliable ways of helping people to understand their entitlements, to articulate and assert their entitlements, and to enforce their entitlements. I also think we'll see new dispute resolution mechanisms emerging, which for many lawyers will be anathema. For many lawyers, they'll seem deeply disturbing. But we will come to use, and people are already working on this in Brazil, in Italy, Singapore, we will come to use AI systems to resolve disputes. I don't regard this as replacing judges. I think that's simplistic thinking. I think we will find another way through AI of resolving, for example, many low-value disputes for which our current system is simply disproportionate. But we'll go further. The use of AI will not simply be in the resolution of disputes, it will also be in the containment of disputes. One of our difficulties in law is that once disputes enter the system, the economic and the institutional incentives are towards the escalation of the dispute rather than its containment. We'll find techniques to contain disputes, and we'll also, most significant of all, be using technology to help us avoid disputes in the first place. I often say to put the fence at the top of the cliff rather than the ambulance at the bottom. And so on a positive side, if we ask the question, what if AGI, it seems to me very likely that the problem that brings many of us together, the problem of access to justice, will in large part be solved by this remarkable technology. And people often say, well, it's a threat to the rule of law. I think entirely the opposite. We will be able to make insight to the law, for example, far more widely available. Insight into any legal system for people of any age, in any language, will be immediately available using this powerful technology. It will reconceptualize, help us reconceptualize how it is we legislate, and much more. So I've been working on AI, as I've said, since 1981, and I've always been optimistic, and you'll sense that in me today. I do believe that we have in AI a remarkable tool to help us crack so many of the problems that are at the heart of this conference. I've always been optimistic. However, as I wrote my book, and I had cause to write a couple of chapters on the risks of AI, and I introduced a new classification of the 7 categories of risk, I also became far more acutely aware of the mountain range of threats that AI poses. And that's why I conclude that saving AI with, saving humanity with and from AI is the defining challenge of our age. Thank you.
Thank you, Professor Susskind, for your compelling insights, sharing of knowledge, and predictions on this very engaging topic. I now invite Mr. Ian McDougall to share his perspective.
Thanks very much, and thank you again for a further opportunity to talk to you about this subject, which, as many of you know, has really occupied my life for the last 15 years or so at Lexis, as we've been working on variants of artificial intelligence, extractive AI before generative AI. I spoke with Richard before we came to this conference, and I said, my job was to try and be provocative and try and find stuff to disagree with him about if I could, because I thought that would make it more interesting for you. He's made it quite difficult for me because I happen to agree with quite a lot of what was said. So, but I'm gonna give it a go anyway. To start off then with a few of my general comments, and then what I want to do is try and give some thoughts about how the profession in particular might consider ways going forward. The avatar video that started this off did, look scary. But what I would say is I remember the Arthur C. Clarke quote that I enjoy very much, which is that sufficiently advanced technology looks like magic. It isn't magic. It's very, very wonderful, sophisticated computer technology. But let's remember that wonderful, sophisticated computer technology has been with us for a long time. And we have been, as a profession, adapting to it up till now. I once gave as a thought experiment at a conference this idea. I walk into my office and I say, lights on, and the lights come on, and I say, computer on, and the computer comes on, and it says to me, you have X number of new emails. And I say, read out email to number 1 to me, and it reads it out, and I say, right, I want to reply to email number 1, please. Dear blah, 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 yours truly, send. And it sends it, and it automatically puts it into my billing system and into my record system, etc., and I move on to the next thing. Well, I gave that talk first, that thought experiment, about 10 years ago. And the punchline to that was that all of the technology to do that already existed. There was nothing new about what I said. It's about voice recognition and language recognition, and nobody works like that. And so the reason that I make that point is because there is a difference between what the technology is capable of doing and what use we actually want to make of it. They're two different things. So capability and the actual use to which we put it are very often two different things. I agree about the profound impact that artificial intelligence is going to have. Why is it going to have that impact on the legal profession? Because until generative AI, and particularly large language models, came along, it wasn't really possible to replicate the kind of skill set that the lawyers had, which ultimately is the generation of, well, I was going to say intelligent language, but let's just say language. And so that was able to be done. But I want to remind everybody about the kind of way that a large language model works, and therefore some of the flaws which we have to overcome. I've mentioned this before, but effectively a large language model is a massive statistical building model, and what it does is it absorbs as much information as it can on language and the relationship between one word to another, and it generates a statistical model that enables it to predict the most likely next word. Which means, of course, that it knows nothing. There is no cognitive skill going on there. And I don't mean to belittle the technology. As I've said before, it's fantastic, it's amazing, and it's transformative. But let's not think about it in terms of this thing is thinking, right? The large language models are not thinking in the sense that we understand. What they're doing is they're playing what Professor Alan Turing called the imitation game. They basically look like they are. And so this is why some of the flaws that we've been experiencing in large language models are actually there, which is hallucinations. They basically make stuff up that isn't true because they don't know what true is. They don't know what moral is. They don't have these concepts. They're building a statistical model of language. And they're using that to get better and better at generating predictive use of the language. Okay, that leads, as I say, to hallucinations. It leads to other things as well, which is that open AI models, as I've mentioned before, like, for example, ChatGPT, but there are others, are, in my view, at the moment, and I agree with the sentiment that, this is the worst it'll ever be, but dealing with an open AI model is, to me, the kind of equivalent in human terms of going into a bar and asking the first drunk person you meet. You might get a good answer and you might get some drunken nonsense, but I wouldn't rely on it. Whereas what we're going to see, I think, increasingly going forward is what I call task-specific AI. AI that has been trained and refined to do a specific thing. So that instead of you interacting with a large language model, you're interacting with an interface which is then interacting with a trained version of a model. Now, the example of that would be a legally trained AI. a medically trained AI, an architecturally trained AI, and so on. And I think that's likely to be what we see. Now, I'm very, very hesitant to disagree with the idea that we're going to have an AI capable of replacing pretty much any human activity because of two things. One, that very famous comment made by the head of the US Patent and Trademark Office in the early 1900s, who said that everything that could be invented has been invented. That comment aged well. And the other thing, of course, is the difficult of predicting anything. I look at the life, for example, my grandparents led. They were born into a world of a horse and cart and left it after having man had walked on the moon and Concorde had been flying. So totally unimaginable transformations that took place. I still, however, have hope that the legal profession, at least certainly in any foreseeable future, will do two things. One, it will survive, not in the form that it is now, but in a kind of form. I'm not talking about 100, 200 years into the future. I'm talking about in any kind of foreseeable future. And I have a couple of reasons for thinking that. Number one is I use by analogy the idea of, and I apologize if anyone here knows or is married to an estate agent, but I ask the question, can you please tell me the unique, specific skill required of an estate agent? People struggle because basically, as far as I can see, there isn't one. And so why do we still have estate agents? I think the reason is because of a wonderful book that Adam Smith wrote many years ago on basically the division of labor principle. The idea is that we have estate agents because they spend their time, money, effort, investment, training, etc., on doing that all the time, and you don't. And so instead of doing what it's perfectly possible for me to do, which is do it myself, or in case of a plumbing leak at home, I could go into any public library or now the internet and look up how to be a plumber. I tend not to do that. I tend to call a plumber in because that person has spent their time, effort, money, etc., doing that kind of thing. But that doesn't mean that what you do today as a lawyer will be what you do in 20, maybe 10, 20, 30 years' time. It will be fundamentally changed by the approach of technology in exactly the way it already has been. If you were to look, for example, at the way that Abraham Lincoln conducted his legal practice, it would be utterly unrecognizable to what you do today. And yet here you still are, despite the fact that anyone could walk into a public library or now the internet and know everything and more about the law than you could possibly ever remember. But here's the importance. I was quoted earlier on this morning as saying that there are only going to be two types of lawyers, ones who incorporate and adapt to AI and those who fail. And I absolutely believe that, because here's the equivalent. I've heard some people saying, oh, I'm not really sure about this AI stuff. I don't really want to get involved with it. And now let me take you back a few years and give you the equivalent. I'm not really sure about this internet thing. I really think I should steer clear of it. And you know, this email stuff, no, it's a fad. I think we can do without that. It's as preposterous as that sounds. This idea that you're going to sit there like King Canute holding the tide of AI back is just not sensible. However, one thing then that I should probably draw my comments to a close on is the way that we should approach this as a profession. Number one, so far the debate has been about things like I mentioned earlier. How does it work? What does it do? How can I audit this kind of thing? Again, I believe these are complete red herrings. to ask that question. Number one, on a large language model that is using literally trillions of nodal connections in order to come up with what it's doing, you're never going to be able to audit that. It just isn't possible to do. And someone in a previous conference I said that to said, oh yes, we do, because I'll ask it how it came to that answer. And I said, that's not an audit, that's just another output. And so that it's just simply not going to be possible. Or, of course, I can present to you 3.5 billion lines of computer code and say, good luck, have fun with that. It's just simply not going to be practical. So really what the profession should be focused on, and this is another reason why I think there is a chance of maintaining a profession as it goes into the future, is you should in fact be focused on things like who's responsible for the output? What rights do we need to be protecting as a result of this? Who is liable in the event of misuse or whatever mischief we think about? These are the real questions that we should be talking about, because I'm reminded of the old video recorder litigation that happened years ago, when the video recorder companies were sued for intellectual property breach. And of course, rightly in my view, the court said that's not the case. It's the video recording company isn't putting the video recorder to use. It is the person who's doing that. So let's stop worrying about how the technology works and some of these other complicated and wonderful things, and start worrying about who's going to be responsible for the effect it has. How can the profession actually incorporate this in a reasonable way? And this is where I think one of the most important things to be considered is the importance going forward of ethical standards. What is it that differentiates the conduct of a lawyer from the conduct of other kinds of work operations? Well, one of them you would like to think so far has been the fact that you are bound by a professional code of conduct that requires you to behave in a certain kind of way. Why should people come to you? Because they think they're going to get the kind of service that involves some sort of professional conduct, some professional standard, these kind of things. I think it's very likely that the thing that will enable a kind of service that's called lawyering in the future, although it may look very different, will be the fact that, one, you've spent your time, effort, money, investment doing this kind of thing. And number two, that people are coming to you because you are in a regulated industry where you have a certain amount of professional conduct that you have to comply with. So I think I was only given this much time to reply. There's a lot more I could say, and maybe I'll get the chance. But the other thing that I would advise you all to be doing is not to be thinking about, there's this new technology, how can I use it? I suggest that you ask the question the other way around, which is that I have a particular problem that I need to solve. What's the best technology I ought to be using in order to solve this problem, in order to deliver a service to the people who are coming to me to receive that service? And the other thing that I hope will happen as well is that the legal profession does not become basically a protective union that sets up obstacles to the administration of justice, to the access to justice, and in fact prioritizes those kind of questions instead of preserving the way that it wants to work. I realize this is a blow because it's my view that there are some elements of the skill set that you have going forward that will be entirely useless in the future. And that's a blow because there's a lot of prestige involved in being in the legal profession, and one of them is being able to sit there and quote bits of law, which always sounds very impressive to people who don't quote bits of law. But I'm suggesting that's going to be entirely useless. And here's my analogy. In the 1800s in London, to be a taxi driver, you had to have knowledge of a horse. You literally could not be a taxi driver if you could not manage a horse. And then the internal combustion engine came along, And what I hope you're going to see galloping towards you is the result of my analogy to the legal profession, which is the skill of the taxi driver then became not so much how do I manage the horse, but how do I interact with the technology in order to produce the outcomes that I want? What levers do I pull and push? Instead of how do I manage this archaic way of doing things? And so I think this is going to become really important. Things like prompt engineering are going to become increasingly important. Your training will cease to be, or maybe not yours, but the generations to come will cease to be, how much law can I regurgitate in a 3-hour period? And will much more become, how do I interact with the technology in order to move the legal process along on behalf of someone who's come to me because they don't do that? That will be a big challenge. It will be a big challenge for the educational institutions as well, because they're going to have to fundamentally revise how they prepare people for a career in the law. But I do agree, and I really agree with this passionately, that if we approach this in the right way, then we have tremendous opportunities for the administration of justice, the speeding up of access to justice for people all over the world. I visit many places around the world, some of them Commonwealth countries, and people talk to me about 20-year delays before getting a court hearing. I've spoken to folks in Brazil, for example, who told me about how their Supreme Court has 500,000 open cases on their docket. Those people have no chance, really, of ever seeing a resolution to many of those cases. And so we ought to be open-minded about how we approach this. But I'm still convinced that if we do this the right way, then for the reasons that I've given, there will still be a need for something which is called a lawyer in the future, even though it looks fundamentally different from the way that you conducted your case. I think I've overextended my welcome, so I'll leave it there, and thanks very much.
Thank you, Mr. McDougall, for your thought-provoking contributions on this crucial topic. And now I pass the floor again to Professor Susskind for his response to what we just heard.
Well, thanks very much, and thank you for your observations. Just a number of thoughts arise from what Ian had to say. I find it always very interesting when I talk to lawyers about AI, and lawyers ask questions such as, what does this mean for lawyers? What does this mean for law firms? What does it mean for judges? There's a contrast here where there's a breakthrough in medicine. People don't immediately say, what does this mean for doctors? They ask, what does it mean for health? And one of my main messages today is for us to think deeply, not just about the impact of AI on our profession, but think about the impact of AI on those who need legal assistance and legal help. That should be our starting point in thinking about the long-term impact of AI on society. We as lawyers should survive and thrive because we bring value that no one else can or no machine can. But the law is no more there to provide a living for lawyers than ill health is there to provide a living for doctors. We have to think, I think, in a far more client-oriented way about the impact of AI on society. A second set of observations, and I don't think we're at odds. My real interest in speaking to you today is not about the next 2 or 3 years. There's many people in Lexis and elsewhere who are deeply expert on the way that AI will turbocharge the way lawyers work. What I'm here to say, and it may sound histrionic, but I say again, 44 years in AI, I'll make a different point, that we've seen more advance in the last 4 years than we've seen in the previous 4 decades. I think we are entering a new era in the history of humanity. I don't think this is an efficiency tool in the edge. I think there's something fundamental going on with this technology for which we're simply not prepared. And one challenge I want to make, this is not so much a challenge, but it's an observation, but it's a theme of my book. There's two ways of thinking about AI. It's what I call process thinking, and there's outcome thinking. And when you talk about large language models and when you talk about statistical models, of course you're right, and I agree that these systems aren't conscious, they don't think and reflect that we do in the way we do, although I do have discussions about whether or not this will always be the case. But for now, these systems are as described. But this preoccupation with how these systems work is misleading in a couple of levels. First of all, generative AI, large language models, is simply the latest version of AI. It's not the first version, it's absolutely not the last version. Even since generative AI systems have been talking about, people are now talking about agentic AI. And this, so the technology is not stable. It's fundamentally changing all the time. Also, that you may gain some reassurance by hearing that the technology is just a statistical model and therefore doesn't have the might of the human brain. That's just how it is today. If you look 10, 20, 30 years ahead, these systems will be underpinned by entirely different enabling technologies. So process thinking is looking at how does the system work. Outcome thinking is looking at its impact, its social impact, its economic impact, its functional impact, its legal impact. And I was struck by the contrasting responses of two of the finest 20th century intellectuals when ChatGPT was launched. One was Henry Kissinger and the other was Noam Chomsky. Kissinger described this as something that will change the very fabric of reality, a greater development than the printing press. Noam Chomsky called it a trivial matter. How can these people think so differently? Well, Chomsky is a process thinker. He looks at statistical models and he says, compared to the language acquisition capability of the human brain, this is technically insignificant. He doesn't seem to have any insight into the idea that even the AI we've got today could be weaponized to very damaging effect. Even the AI we have today can help with medical diagnostics, with education, with access to law. He is simply looking at the innards. Kissinger is entirely different. He's saying, look at the impact. Look at what it's already doing. Look what it's likely to do. And what I find in law is people take some comfort from the idea that somehow these systems are just ones and zeros. I could see equally we're just molecules, but they take comfort from observing these systems are ones and zeros, somehow lapsing into process thinking, whereas what we should really be doing as lawyers is thinking about the impact on our clients, the legal implications of these systems. And as I said earlier, even extrapolating these systems are going to get wildly more capable. But if you take into account the as yet uninvented technologies, if we speculate a little, we're in an entirely new realm. And my question to you is, what's your legacy? Most of you, I look in the room, I'd say most of us in our 60s, and the thought often is, can I hold out to retirement before this stuff engulfs me? And this is deeply unhealthy, and our children's children won't thank us for this. My question is, what are we going to do in our generation? And remember, again, I'm not predicting AGI, but I'm saying it's such a significant possibility that our generation has to put contingency plans in place, both for ensuring that this system is used radically to increase access to justice and using our might as lawyers, as legislators, as judges, as legal academics to ensure that this technology is appropriately regulated and controlled. We can lapse into thinking, oh, it's never going to get that much more advanced. From my heart, I can tell you that the systems are moving ahead at a ferocious pace. It's not, I look back for 35 years. I can't even look forward 35 years. I can barely look more than 10 years ahead. But I think it's incumbent on us, as leaders in the legal world, at least to take seriously the possibility that these systems are going to become unfathomably capable.
Now we will open the floor for any questions and comments. I can see a hand over there. Two hands, actually.
Good morning. My name is Immaculate Kasait, Data Commissioner from Kenya. And thank you very much for that very insightful discussion. It's a conversation that we all honestly need to have. My question is twofold. One, we've just come from the first African AI conference in Kigali, Rwanda, last week. And the concerns which I would want us to, we are speaking legal implication. But how ready are we in the Commonwealth on the following issues? Infrastructure, can we power up AI? Human resource, do we have the capability even in the legal profession to do AI? 3, issues around computing, are we ready? Do we have the necessary data centers to make sure this is happening, even as we have a conversation? Because even if we speak about AI and we don't have the necessary infrastructure, are we going to be caught flat-footed? And finally, my question is around guardrails. Around there, you've mentioned it, but are we actively discussing those issues? Thank you.
Can I respond to that? Say a little, given the context. So I'm Special Envoy for Justice and AI to the Secretary General of the Commonwealth. And so we're looking at, and we call the project as AI for Justice, and we're looking at how we can use AI to increase access to justice. Your question's a fantastic one, because the approach that's emerging for us is to some extent to assume these technologies are going to be capable in the 2030s and ask, are we ready for them? What we don't want to do is wait until these technologies in the early 30s are doing remarkable things. They're helping people understand, assert, and enforce their entitlements, and yet we don't have the infrastructure. We haven't thought about the regulation. We've not coped with the culture. We've not adapted the legal profession. So we're turning it on its head on the assumption that this technology is coming through. Might be 28, might be 30, might be 35, it doesn't matter. What do we need to do to make sure that we can maximize the use of that technology? And so turning the advance and adoption issue on its head. So your questions are bang on. And the reality is, even if massively advanced systems come through, we're not ready to adopt them today. We haven't had the public conversation about their use. It's not just in law, it's in health, it's in education and elsewhere. So there's a lot that we need to do, the foundations we need to put in place to make sure that when these technologies are available and are reliable, that we can immediately put them to work. And that's basically the focal point of the project that we're working on. It's tremendously challenging, but that's a great question. And guardrails, this idea of how can we build within these systems certain kinds of rules and regulations that govern their own use, that prohibit their use in certain circumstances and so forth. That also has to be part of how do we control these systems as they emerge. But thank you very much for the question, because it really is fundamental to our method not to delay asking these questions until the technology is available.
If I can just add to that, it's one of the reasons why I have this obsession about stopping people talking about, well, not stopping talking about, but focusing on how the thing works. Right? This is taking us down the wrong track. I've emphasized before, we should be focused on who's liable for it and what are the implications of its use in certain circumstances, etc. The other thing that I think is really important is that it's why I tried to explain earlier on about how it works and that kind of thing, because once you realize how it works, you realize that that's a completely the wrong approach to go down. So what I would like to see is much more discussion on the kind of topics that you've mentioned, and a lot less discussion on people focused on how the thing works.
Can I just add, it's not really in direct response, but it's something that we should all bear in mind. One of the questions is the extent to which our legal institutions are prepared for this technology. So I think of the idea of how we legislate and how we regulate. I look, for example, at Europe, at how they've tied themselves in knots with their AI Act, and it's taken years. My challenge is, do we have the legislative processes, the regulation creation processes? Are they sufficiently agile to cope with a technology that's going to throw up new challenges by the day? And many of my friends in England will say the English common law system is ideally placed to adapt and reflect. Again, I think there's an issue of speed, that these technologies will raise new inventions, developments will raise acute issues that will need fairly immediate attention. And I'm not even sure we have the legal concepts in place we haven't really thought through the extent to which we grant some form of legal personality to these systems, whether or not and how we might hold them accountable. We're having a big debate about copyright law and its applicability. And when you think about it, certainly in the UK and the US, our copyright concepts are based on 18th century thinking that were actually evolved to match the printing press. The idea that that scheme of legal thought would be easily applicable to emerging and advanced AI seems to me to be naive. So we've got some thinking at a fundamental level about our legal institutions and our legal concepts and making them AI ready. It's as big a shift as from the society based on script to the society based on print. And we saw in that transition, legal historians will show us how so many of our institutions, the way we practice law, the way we decide disputes, and so forth, they change. Similarly, they'll change with this shift.
Thank you. We have another question over there, and following that, we have a question at the side as well.
John Logan, Federal Court of Australia. I have a Criminal Justice Administration question. Are we going to see in the next little while a marrying up of facial recognition technology, drone technology equipped with TASers, and with that, a scenario for a new tort of, or a new scenario for a tort of wrongful arrest, whereby a supposed villain is supposedly facially recognised, arrested by a drone and tasered for resisting arrest, only to turn out that it's the wrong individual.
Whether we handle that by tort law, as I say, maybe by holding AI systems and those who develop them or are accountable for them vicariously, giving them some kind of legal personality, I'm not sure. But if you're identifying, if you're suggesting that AI systems can and will give rise to new forms of offense and difficulty and problem, I absolutely agree with that. And that's another respect in which our law has to develop to anticipate and cope with new forms of problem. And it's not just simply an offense, it's the extent to which and how the state is held responsible for the deployment of these technologies. Again, our thinking on this is very primitive.
And I would just like to add to that that all of the technology, it already exists for all of the stuff that you've just announced there: facial recognition, drones, tasers. they're all there already. And I suppose what came to mind as you was describing that is, what would happen if I just put a human into that process slightly? So let me give you an example. What would happen now, for example, if the drone comes along, identifies mistakenly a suspect, and tells the police officer that this is the suspect wanted, potentially armed and dangerous, and therefore there's an arrest warrant. And the police officer goes in and then, as a result of that, tasers and arrests the person concerned. I just asked the question because I haven't had time to properly consider it, but we already have processes to consider what would happen in that situation, don't we? And so, although I take on board your point about the adaptation of law to the new world, there are some times when I think we can already cope with some of the scenarios that I hear. What I'm just keen to avoid is the idea that we are incapable of dealing with many of the scenarios that we talk about, because many of the scenarios we talk about are simply the use of computers. Yeah, and we already use computers. And so I think my first reaction would be, can existing law cope with this, and then to consider alternatives. Because the point about the way that the systems work, the computers work, is I, at the moment anyway, liken this to the atom. Now, the atom doesn't know whether it's in a bomb or whether it's in an electricity generating machine. It just does what the atom does. Yeah? And so I'm very, very keen to try wherever possible to make it clear that there should be some human being, potentially, or organization that's responsible for the outputs and the decisions that are made as a result of the information given. And it may not be the best analogy in the world, but I liken this actually to something that was mentioned earlier, which is the calculator. Now, there's not a single person in here, probably, who has looked into how the calculator is actually working. Right? What we've done is we've become so used to its accuracy, we now no longer bother. But what happens with the calculator is that it does now the grunt work that used to be done by a human being, and the human being now takes the output of the calculator and does something of a higher value with it. And I'd like to see if it's possible to hang on to that methodology or that way of thinking with regard to our interaction with more sophisticated computer systems, yeah? Which is that they're doing something for us, and which previously perhaps a human did. But now what we have to deal with is the output from that system and what happens as a result of what it's giving us.
I don't think anyone would not want these, or someone to be accountable for loss or damage or injury that flows from the use of these systems. The interesting policy question is, for a particular category of social issue we're trying to address, do we want to say this should be done by humans alone? Do we want to say this should be done by machines alone? Or do we want this to be a combination of humans and machines? And I think the answer to that should not be based on instinct. It should be based on evidence. And that's another message for everyone in the room. I find in AI, people have very strong instincts. And you'll all have a view on what you've heard today. And in the nicest possible way, I just ask you to do your research, to read more, to understand more. I find when I say to people I've written a book, they often say, what's it on? Tell me about it. When I say I've written a book on AI, they tell me what they think about AI, which is in one sense healthy, but we have to rise above our instincts and do what lawyers do best, which is read, research, learn, understand. And our challenge is to think how best to integrate this remarkable new set of emerging technologies into our society. And as I say, that might be autonomously, it might be that we completely prohibit them, or it might be that we have humans in the loop. It's not a great record of humans working successfully in high-tech loops, incidentally.
So we continue with our questions. We have a question at the very front.
Thank you. My name is Delano Bart, and I'm from the Caribbean. I share your view that the time will come when we should look at the client in the same way as the doctor looks at the patient. But what I would regard as the elephant in this room is essentially this. With maximum efficiency flowing from AI, inevitably it raises the question of the ethical aspects in relation to billing of the clients. And I just wondered what your thoughts would be on that.
Yep, I can give you a go of that one, which is that so far, again, I'll prepare you for what may be an unpopular opinion. The legal profession has got away with one of the biggest scams in history, which is the idea of hourly billing. The idea that I'm going to bill my client for the time that I occupy myself doing the work for them, regardless of the value that that has to them, is really it's a wonder it still survived. And there have been discussions over the past about whether the hourly billing will eventually end. People like me who moved into corporate world kind of had a big influence in stopping corporate law firms from billing me hourly. But that discussion kind of never really concluded anywhere. I think that when you are in a situation where, for example, in the legal technology world, you can produce a draft of a statement of claim inside a millisecond, I don't see how hourly billing survives that. So I think what the legal profession is going to have to do is to really re-examine its way of billing and introduce what I call value billing, which is fundamentally the way that most other service industries kind of work. And of course, like Mark Twain said, the death of hourly billing has been greatly exaggerated. But I do think that the technology now already exists to put that heavily under pressure. I think the legal profession is going to have to start billing for value rather than for time.
There are obviously difficulties for charging for essentially input rather than output. It's not always anomalous, but generally is. But the bigger and longer term issue here is that the way that the business model underpinning law firms today is charging for the time of human beings. If, as I suspect, more and more clients will be using systems, then tomorrow's lawyers, and that's a concept I've articulated in a book of that title, tomorrow's lawyers are people who will be delivering legal content, legal advice, legal guidance in the form of systems. So we will move from charging from our time to licensing our content and licensing our technology. And if you want to see an analogy of this, the global tax businesses, they no longer do their global tax compliance in a handcrafted human charge by the hour way. They essentially have developed very complex, they're like first generation AI systems, in fact, which allow major companies across, say, 50, 70, 80 jurisdictions to do their own tax work. And the big four, for example, license the use of their software and systems. Now, many lawyers say to me, well, hang on a second, I'm not a technology provider. It's going to be hard to move into the 30s without being, in some sense, involved with technology. But the bigger point is you are, as a lawyer, and you'll never put it this way, you are a content provider. You just now dispense your content in the form of one-to-one advisory service, usually on an hourly billing basis. In the future, we will license that content in the form of AI systems. And this, for me, is the future of the legal world, that we develop the systems that replace our old ways of working. Clients will need AI systems that offer advice and guidance in law. There'll be a new wave of legal professional who will precisely develop these systems. You may or may not take comfort from that. There is a role for tomorrow's lawyers, but it's not the advisory hourly billing model that we have today.
So we have the question at the front and another two questions, and those will be the last questions.
Thank you for your insights. It's been an interesting discussion. I'm Alison Holt, a judiciary advisor to the Judiciary of Papua New Guinea, and I have my Chief Justice and my Deputy Chief Justice, two of the judges here. Over the last 24 hours, we've been talking about our court rules and our practice direction. And we're very keen to put something in place that has some longevity. So if we've seen other practice directions that talk specifically about generative AI and open AI models. And how do we be general in a way that we can have rules that live as AI develops? And how do we take an approach that actually balances the risk with actually this huge value to provide access to justice? Thank you.
Well, you're asking massive questions there. It's very clear. In a way where you're asking the question which we always like to ask, which is, how do we future-proof judges, lawyers, our legal system? And I think the concept of future-proofing is now irrelevant. I think we simply do not know how the technology will unfold, how quickly it will unfold. But as a generality, I think that having large bodies of complex rules that apply to the particular technology of the day can't be the way ahead. We have to move, and it's true in our regulation of AI as well, towards more principle-based thinking. I want to tell a very short story, but there's a company in the UK in which I have no financial interest, but I know the guys who run it, called PINQDR, P-I-N-Q-D-R. And it's founded by one chap who's a young KC and another is one of the senior litigators in a big international firm. And they provide an online dispute resolution service. But the point I wanted to highlight was that they've taken essentially the rules of court and the practice directions, put them to one side for their process, and they've created a 9-page document that governs the use of their dispute resolution process. I think we keep on layering more and more layers of complexity. And so when people come to me and say they will perhaps want to simulate, emulate, replicate the systems of the UK, I would want to challenge that. I think in an AI era, we should be starting with a blank sheet of paper and saying, if we could start from scratch, what would our dispute resolution process look and feel like, given this combination of humans and AI systems? And in light of what I'm saying about the unpredictability of how it's going to unfold, what set of more general principles could we put in place that would govern that process? Otherwise, what I fear we keep on delivering is mess for less. We have a messy process and we're using technology to make it a bit more efficient. But Lord Dyson, who was once the Master of Rolls in England and Wales, once said, any system that has got a 2,000-page user manual has a problem. And he was referring to the White Book in the civil system of England and Wales.
Yeah, well, that last point I completely agree with. But this is a particular kind of passion issue of mine because, as I say, too many people, I think, are focusing on the wrong thing. So, for example, I've seen some court around the world wanting to ensure that an advocate discloses whether they've used artificial intelligence system in the product that they're presenting to the court. I can't think of anything more irrelevant than that. And here's why.
Completely agree.
Yeah. and I mean, here's why. You are or not you, but the advocate or whoever is responsible for the material they produce to the court. That's where I think the rules of the court should focus on saying, or at least re-emphasizing, if it doesn't already say so, that the advocate's responsible for what they produce. I don't care how they've produced it, but it should be accurate, it should be sworn to, etc. And the equivalent that or rather the analogy that I give to people is that when I presented to the court, I was never ever required to say, and by the way, Your Honour, I must disclose that not all of these words were spelt correctly first time by me. This was Microsoft Spell Checker, and as a result of that, I must disclose this piece of technology that I used. And it's just ridiculous. The calculation of damages that I'm going to present to you, I must confess it was done by a calculator, and I did not check the calculator with a pen and paper. I mean, how crazy does this sound? It's not relevant about what particular type of tool or technology you used. The focus should be on who is responsible for the material being presented to the court. And I ask people, I was fortunate enough to write the position paper for the Law Society of Hong Kong on the use of artificial intelligence, and this was one of my many recommendations, which I'm pleased to say they mainly adopted, which was about focusing the rules of conduct and the rules of the court on making sure that people understand that they're responsible for what they submit to the court. And part of the reason for that as well is also because the technology is so open to change, the speed at which the technology is changing is increasing. You're going to end up having to rewrite the rules of the court each time a new piece of technology comes in. It's not sensible. And also, I don't believe that's where the responsibility should lay.
So, thank you. We have another question at the center of the room and at the front. I think we can take all the questions together because of the constraints of time.
Thank you for the presentations. My name's Fiona. I'm the Independent Regulator of Lawyers in the state of Victoria. I agree with you both that we should be focusing on the outcome impacts of AI and not the process impacts. It's something that I emphasise when I talk to lawyers about the use of AI. But I've got a hypothesis I'm interested in hearing from you both about. I think that it is sometimes hard for lawyers to think about process, system and outcome impacts because their training directs them mainly to process impacts. They're often not good system and outcome thinkers. So I'm interested in how you think we need to train lawyers who are entering the profession, and also the idea of continuing competency and where this shift to outcome and system thinking should come into the way lawyers operate.
We'll take the other question at the front of the hall.
Thank you. Firstly, can I just say this has been an amazing discussion, so thank you very much for it. I agree with the points that were made regarding the outcomes and why it is the end user, meaning the client, that actually needs to benefit from the AI if it's being used by the lawyers. So I just wanted to ask the question, when we entrust AI with decisions once governed by human conscience, are we outsourcing morality or are we quietly redefining it?
There's so many questions going on here. On the training, I would just say to you, we have the fundamental question, what are we training young lawyers to become in light of this kind of presentation and discussion? And my fear is our law schools are churning out 20th century lawyers. So we need to completely rethink what it is what it is we're equipping our young lawyers with. And it will be a different mindset and so forth. And I do appreciate that a lot of what we've been saying today is uncomfortable and doesn't align with conventional thinking, but this is just an indication we need to, from law school onwards, rethink. The question you ask is, I keep on saying it, but there's something I've written about in my new book. Immanuel Kant, the great philosopher, famously said that he marveled as much at the starry skies above as he marveled at the moral law within. And it is a very strange and almost inexplicable feature of human consciousness and human being that we have this sense of morality. Now, I'm not discounting the idea that very complex systems hundreds of years from now, there's some form of consciousness may arise, and I discussed that. But for now, I think a feature of human decision-making is it's to at least some extent driven and contained by our sense of what's right and wrong, good and bad. What you would get essentially from a system is not an output that was delivered with this visceral sense of correctness or rightness, but you may get an output of a system that reflects, and you may or may not want this, common or popular morality. So the system might, you say, deliver the right reason, rather the right answer for the wrong reason. But we shouldn't be, again, it's process thinking to be thinking, are these systems themselves driven by moral conviction? In a way, what we need to think is, do we find their output to be morally acceptable? And what we don't have, and this is my final observation of the day, in medicine, we've got, for example, randomized control trials. We've got double-blind peer review when new pharmaceuticals or new medical devices come onto the market. We have ways of formally reassuring consumers and users that whatever is out there is reliable. We don't have anything like that in legal AI. And if we're developing systems that are going to be advising on legal issues or going to be resolving legal issues, then I don't say we will assure the public that they have some strong sense of moral sentiment, but I do say we have to have the processes which can reassure people that we have tested and validated, designed these systems in a responsible way, in a way that's confirmed for us, perhaps by running them several million times, that their output would accord with human decisions that we would regard as human, as morally acceptable. It's complex stuff. None of it's deal-breaking for me, but we've got to think it through.
I would like to try and combine the two questions into a single answer, if I can, which is something that I advocate whenever I talk, which is we need to coach, train, educate people not to become tech zombies, by which I mean the passive recipient of whatever the thing is throwing out at them. I think, at least for the foreseeable future, this is going to be important. I think part of the problem that we have on social media is that too many people are tech zombies and are passive recipients of whatever the thing is throwing out at them. So I would say, on the one hand, the education establishment, the professional training establishment has to kind of keep reinforcing that what we have at the moment with the technology, with the AI technology, is a good assistant, a good provoker of what you should be doing. If we take that to the next level and we keep viewing the AI system output as a good provoker of what we should be doing rather than a decider, then perhaps that's a good way of looking at it. But I'm concerned that in the way that I quoted Arthur C. Clarke, people look at this as some kind of magical thing. It isn't, but what it is very sophisticated, fantastic tools, but that doesn't mean that we should be, as I say, passive recipients of it. And the last thing as well, interesting for the common law world, I just leave this as a thought and a question, because I haven't really determined the answer myself. If I were to say that some of these cases are going to be decided by the AI system, well, I wonder whether we would ever have had Donoghue and Stevenson, for example, where at every stage the law was against the applicant in that case. And I'm pretty sure that if you had received advice from a modern AI system, it would have said you've got no chance of winning that case, or at least very little chance of winning that case, because the law was completely against the applicants in that case. So again, there's just a warning there about being a passive recipient of the output.
Thank you. So we come to the conclusion of this very engaging plenary. I would like to highlight two main key takeaways: the impact of AI on legal practice. So while AI is set to reshape profession, the fundamental principles of justice, fairness, accountability, and human oversight must remain paramount. And secondly, the role of regulatory bodies. Institutions must take a proactive role in defining AI's place within the legal profession, rather than allowing AI to define the profession itself. Finally, I extend my sincere gratitude to our distinguished panelists for their valuable contributions, and to all the participants for engaging in this vital discussion. I trust we are leaving with a deeper understanding of the challenges and opportunities that AI presents within the legal sphere. Thank you.